Hello.
And we're live.
All right. Well, welcome everyone to the Ask Your Attorneys Q&A that the Legal Rights Center has. We have our awesome attorney Josh here today to answer some questions. Feel free to put questions through the chat and we'll try to get to as many questions as possible. The Legal Rights Center likes to put these events on. We're a community-driven nonprofit law firm that really specializes in adult criminal and juvenile delinquency defense, with an overall vision of really improving the experience that communities and communities of color throughout Minneapolis have with the legal system. So thanks everyone for being here.
I'll echo that. Thanks.
So Josh, just to start us off with, do you want to kind of tell us a little bit about the sentencing process and how sentencing will work now that we have a verdict in?
Sure. So let's jump in. So yesterday we got the big news, and Derek Chauvin was convicted on all 3 counts. So that's a conviction for murder in the unintentional murder in the 2nd degree, unintentional murder in the 3rd degree, and manslaughter. For starters, he's only going to get sentenced on the top count of that. So the unintentional murder in the 2nd degree is going to be the offense that's going to control the scope of his sentencing liability. And we've got some steps to go through before the court makes the determination about what that's going to be. And I apologize if I get distracted here for a minute. My dog and cat just decided to have a wrestling match as soon as we went live, of course. So the first issue is that the state has filed their intent to seek an aggravated sentence, or what's called an upward departure. So what's going on here is that in Minnesota, the ultimate range of the sentence is controlled by 2 things. One, the legislature, when they defined the crime and codified murder in the 2nd degree, attributed it to a maximum possible sentence. And so you probably seen this in the media, that the maximum penalty for murder 2 here is 40 years in prison. So there's no ability for the judge, no power for the sentencing power for the judge to go beyond that. 40 years is the ultimate maximum. But and every criminal statute has that in Minnesota, but that number usually doesn't have much to do with what the actual sentence that someone receives is. Instead, that number is controlled by Minnesota's sentencing guidelines. And we've got this guideline system that's been in effect since the 80s, and there was sort of a movement towards this in the 80s. The kind of the idea of it is to sort of standardize sentencing across regions so you don't see big disparities in the types of penalties that people get. And we've got a sentencing guidelines commission that creates this set of guidelines that sort of gives this sort of standardized number. And the number is based on 2 things: the severity of the offense and the criminal history of the person being sentenced. And if you were to go look, the guidelines themselves are sort of organized in a big grid with those 2 issues forming the X and Y axes of the grid. The murder 2 is classified in terms of its severity as a severity 10, which is a very high severity offense. And Chauvin is going to have 0 criminal history points, presumably coming into this, because he wouldn't be able to be a police officer if he had a criminal history score much higher than that. And that gives a presumptive sentence for that murder 2 charge as somewhere between 128 months and 180 months. So that's about 10 and a half to 15 years. Now the state is going to ask for a sentence higher than that 180 months. But to do that, the law requires that a finder of fact, typically a jury, but I'll talk more about that in a second, make findings on factual issues related to the case that justify going higher or departing upward from that range. And that's what we call the Blakely issue. Blakely is a U.S. Supreme Court case that created this requirement that anything that increases the penalty that a defendant receives is something that has to be found by the jury. However, in this specific case, Derek Chauvin has actually waived his right to have the jury determine those Blakely factors. And instead, the parties are going to submit written arguments, and Judge Cahill is going to make a decision on those Blakely factors. And the state has listed a bunch of them that they're seeking. So these are sort of the justifications why, you can kind of think of it as the justifications for why the case is more serious and should be sentenced at a higher penalty than a typical case of its type, right? And so the state is arguing that it was a crime that was committed by 3 or more participants, that it was committed in the presence of children, that it was committed by a police officer, and the police officer used his status and his license as a police officer to facilitate the crime, that there was particular cruelty, knowing that the victim was handcuffed and in physical and emotional distress, that he should have known, that Chauvin should have known Floyd was unable to breathe when he went unconscious, that the crime was committed despite pleas from eyewitnesses and the victim themselves, that it was continued after he was unconscious, that Chauvin showed disregard for Floyd's life, and that the defendant actually impeded the efforts of others to provide medical assistance. And I just got to give a hat tip on that. You might see me reading from my phone there. There's a great post on the Minneapolis subreddit by user Newroch that helpfully summarized those and a lot of the issues related to sentencing. So what'll happen next then is Judge Cahill will decide which of those factors are proven to be true. I would think that many of them will be, although the judge may decide some of them, even though they're factually true, don't justify an upward departure. And then as long as there's at least one of those factors that is proven to be true and justifies an upward departure, then that would authorize the judge to go above that 180-month presumptive sentence. So after that issue is decided, we'll start moving towards the actual sentencing hearing. Both parties are going to submit written briefs where they'll make arguments about what the sentence should be. At the sentencing hearing, which may actually, usually these, last, anywhere from 20 minutes to an hour or so. But I could see in this case, the sentencing hearing lasting a lot longer than that, even multiple days. But a couple of things that will happen there. Both parties will get a chance to present oral arguments that will supplement their written arguments in their briefs. There'll also be an opportunity for the judge to hear victim impact statements. And so these can be statements from anybody sort of in George Floyd's life that wants to tell the court how this crime has affected them. And then in the defense argument, they can present witnesses too, including Derek Chauvin himself. Will have an opportunity to address the court. It'll be interesting to see if he does there, given that he didn't testify at the trial. But often defendants will choose to do that. The sort of different reasons that you might not testify in a trial that don't play into the sentencing hearing as much. And that's sort of his one opportunity to sort of give a personalized statement to the judge in his defense. There'll also be a pre-sentence investigation that is prepared by probation that will provide, information to the judge about Derek Chauvin and sort of all the factors about his life that the judge may want to consider in terms of sentencing that are beyond kind of the specific facts of the case that the judge has already heard. And then the judge will make a decision.
All right. Yeah. We just got a great question in from the Facebook chat. And I think it even ties into one of the questions that we kind of have received generally. It's with sentencing for only one conviction, and is that unique to Minnesota? Because a lot of people seem to remember there maybe being sentencing for consecutive sentences. And just kind of in general, how does having a defendant being found guilty on multiple counts of both murder and manslaughter work with sentencing?
So I only practice in Minnesota, and I'm not really in the best position to talk about how other states do it. I could try a little bit, but maybe to start off with, it might be helpful to talk just a little bit more about how Minnesota does it. Basically in Minnesota, typically in a case like this, well, typically in any case, you'll have the trial will be sort of focused on the crimes that come out of like the same course of conduct. So you'll see like the murder 2 and murder 3 charges are good examples of this. They're both crimes that sort of flow from the same action, and they're different criminal statutes, but it's the same sort of set of actions that is violating the law in multiple ways. And so when that happens, at least under Minnesota law, and I would think in most jurisdictions, you can only be punished once for kind of the same thing. Sometimes you'll have what's called lesser included offenses. And in this case, I think the manslaughter offense is probably a lesser included offense for the murder 3 charge. And that won't even get a conviction entered into it. It's just, not only will it not be sentenced, it won't even be a conviction. It'll just be sort of rolled into the murder 3 conviction. But the sort of the basic rule is, as long as it's the same, it's the sort of the same conduct that's just criminalized in multiple ways, you only get the one sentence. We do run into a situation in Minnesota, where someone can be sentenced even at the same hearing for crimes that involve different different behavioral incidents. So the clearest way would be if that's like 2 separate things on 2 separate days. But even technically, it could be 2 different, 2 completely separate crimes that occur sort of close to each other in time. And in that situation, you do get separate sentences for both of them. But in Minnesota, all of those sentences are presumed to be served not consecutively, concurrently. Brain fart there for a second. So Minnesota, we serve them all concurrently. So basically, you can serve, jail sentences for multiple crimes at the same time, and each day that you serve will actually get credited towards each crime. And you can kind of serve them all at once. And that's just how Minnesota does that. I know that other jurisdictions don't necessarily do it that way. I know like the federal government, for example, has the opposite presumption that sentences are served consecutively. So if you got to do a year on one and a year on the other, then you do the entire year on the first one first before you even start serving the sentence on the next. Oh, one more note about what to expect for Derek Chauvin's sentence. Whatever the number ends up being, in Minnesota, you typically do 2/3 of that sentence in prison. And then the last third of the sentence you do under what we call supervised release, but what lots of people would sort of colloquially think of as parole.
All right. So now that we have this conviction with the verdict, what are some of the bigger concerns moving forward for the prosecution dealing with the issue of appeal?
Sure. Well, so Derek Chauvin is certainly going to appeal. You almost always try to find something to appeal on any case that goes to trial that has, a penalty as significant as Derek Chauvin is going to be facing. I don't want to be presumed to be able to identify all of the issues that they're likely to raise. They'll comb through the entire trial transcript, all the pretrial litigation, discovery, and they're just going to try to find every possible issue that they think, they could potentially make some headway with the Court of Appeals. Even trying to pay attention to the trial as much as I can, I still don't think I'm in a position to even come close to identifying all of the things that that they probably will, which isn't to say that all of their arguments will end up being accepted by the Court of Appeals, but the way it's set up, you want to raise every issue that you could potentially raise that could potentially work, even if it ends up not working. A couple things did jump out to me throughout the course of the trial and the closing arguments, just based on objections that the defense attorney, Eric Nelson, was making. I know there was an objection towards the end of the day on Monday with, I think, Jerry Blackwell's rebuttal arguments. Eric Nelson objected a couple times to language that he was using there that was sort of belittling the arguments that Nelson was making. I think he used words like shading the truth and telling stories and those types of things. And that is an area where there's a fair amount of case law that does limit kind of what the prosecutor can do in terms of making, how they're framing kind of the nature or the quality of the arguments that the defense is making. And kind of the idea behind that case law is that a prosecutor's job is more than to just win. Their job is to be kind of a steward of justice and help make sure that there's an unbiased jury. And that those types of arguments, especially coming from a prosecutor who's got sort of the authority and the legitimacy and kind of the presumed trust of the state behind them, I think, there's a very real kind of trust imbalance that most juries have with respect to the state, who's sort of just inherently naturally doing their job, and the defense, who is on their back foot. They're defending themselves. They have to, presumably they'll say whatever they have to say in order to try to defend themselves. And that's a sort of a very real dynamic that I think our courts of appeals are kind of acknowledging in some of this case law, and puts limits on how far a prosecutor can go in making some of those statements. Eric Nelson actually asked for a mistrial based on some of those things, I recall, which Judge Cahill denied. Judge Cahill did sustain the objections, though, and gave it a curative instruction to the jury to disregard those statements. And so I think that's one issue that will be raised. I don't know if it's going to be enough, to be a problem for the state, but I definitely think it's an interesting issue. And then the other big one that sort of I thought kind of jumped out throughout the trial was the judge's decision not to sequester the jury. Again, the judge has a lot of discretion in that. So I don't know how far it will get with the Court of Appeals, but it was an objection that Eric Nelson kept raising over and over again, and frankly kept coming up over and over again as we had current events crop up in the middle of this lengthy trial that the jury could have been exposed to. So back up for a second, Eric Nelson had asked the judge to sequester the jury throughout the entirety of the trial, which would have meant that they weren't going home. They were living in a hotel through the whole thing. And that they wouldn't have had, any access to media or social media and stuff like that. Judge Cahill denied that request. He did not sequester them until they started deliberating. And he did instruct them, to, avoid any news about the trial and don't talk to anybody about the trial. But I think they were allowed to access some media and some social media as long as they were avoiding the trial. And so then during the pendency of the trial, we saw a couple things happen. We saw news break early on about the city's settlement with George Floyd's family. And then we saw Dante White getting killed, and the civil unrest that followed from there. From that, then we saw various politicians making statements, and Eric Nelson renewed his his objection to, or his request that they be sequestered, and his objection to the fact that the jury is potentially exposed to all of these current events that could influence their ability to be impartial. And I think that'll be another one. And yes, Dante Wright, thank you.
So Josh, if we could move a little bit in the future, now that we have the conviction of guilty on all three of these charges, what can we expect in kind of plea deals for the other three officers, expecting that they wouldn't want to go to trial? Do you expect them to take plea deals? What's that look like?
I don't know on that one. I think the state's case is a lot harder against those three in some ways, and that might be a reason for them to actually want to go to trial. And just the reason for that is that they they weren't the ones actually carrying out the killing of George Floyd. Now they are being, they're charged with aiding and abetting, and so that means that the state would have to prove that they were aware that Derek Chauvin was committing a crime and that they were helping him and commit that crime. And I think that sort of readily you can kind of start imagining some of the arguments that they'll make there, right? Is that they didn't know that, especially because Chauvin was sort of the superior officer there and was training one of them, that they were just following his lead, and they assumed that he wasn't breaking the law and that what he was doing was authorized. So that might be a reason that they would go to trial, that they've got other arguments there. On the other hand, it certainly makes it a heck of a lot more likely that they won't go to trial now that Derek Chauvin was actually convicted. And that could lead to a new round of, plea negotiations between them and the state. So yeah, we'll just have to see. It can be a really sort of personal, an individual decision for a defendant to decide whether to go to trial or not. And people have, different tolerances for risk in that regard. And if the state is willing to make a plea offer that sort of substantially cuts into, the amount of prison time that they would have to serve, that could get pretty appealing, knowing that Chauvin was convicted.
Yeah. I know I totally basically asked you to break out your crystal ball on that question a little bit. So thanks for that answer. I guess now just kind of moving forward with just a couple questions just about overall, how do you see this sentencing going? How do you see it playing a role in the general kind of movement that we've seen to hold policing accountable? I know that the trial was a good first step. What steps could you see in sentencing that could add to the accountability that we've seen so far?
Well, I mean, I think if I understand the question, it sort of gets to what's the connection between the outcome in this case and whatever outcome we might get at sentencing, and the broader issue of needing to reform police practices in a way that stops so many people being killed by our law enforcement. Is that sort of what you were getting at, Emmanuel?
Yeah.
Well, I get that's a little bit of a tough one. I don't know really that there's anything in the sentencing that's really going to do that, frankly. I guess theoretically, you could argue that a big upward departure here with a long sentence is something that sends a message to other officers and serves as a general deterrent for future criminal acts by officers. That's certainly, that idea of general deterrence is sort of, this idea, right, that we use the criminal justice system and we punish people to send a message to the rest of the community that this behavior isn't okay. And that's one of sort of the pillars or the kind of primary justifications for why we punish people with prison, and jail and probation and all the sort of tools in the carceral toolbox, right? I am not convinced, after practicing as a criminal defense attorney for 10 years and thinking about this a bit and seeing some studies on it and going to some CLEs on it, that general deterrence really works the way that we assume it does. I don't know that there's a lot of clear evidence that people think about things like that when they make the decisions that lead them to end up facing criminal charges. for example, it's hard for me to imagine that Derek Chauvin was thinking at all about the potential of a trial and the potential of being found guilty of murder when he was engaged in the act of killing George Floyd. And I'm not sure that I would expect the next officer to think that much about it either. So to me, from that perspective, I think this trial was important because it's important to hold, one person, Derek Chauvin, accountable for the crime that he committed. But I don't see this as being something that really has any impact in itself on the rest of the system. In fact, I could see it going the opposite way, right? I could see people who are sort of willing to dig in and defend the status quo look at it and say, well, the one bad apple was taken care of. I mean, that was kind of even the state's argument on their opening, right? Was that, look at, this is the system working. Look at all of these officers who should be commended for coming out and testifying against their fellow officer, as if there should be any other expectation at all whatsoever when one of their own commits a crime. And I think you could sort of see those folks digging their heels and be like, well, we can convict a cop for killing a black man in Minnesota. What else do you want? And the reality is there's a ton more that we want, right? We want a complete overhaul of the cultures in these police departments, and a completely fundamental shift in what we ask law enforcement to do on a day in and day out basis, and how they interact with our community. And none of that is going to happen because of anything that Judge Cahill does at sentencing.
Yeah, I know you mentioned, in your answer just a little bit about the kind of overall reform that we need to see, in policing generally to really solve some of these problems. Can you speak a little bit about, qualified immunity and maybe how ending that could possibly help prosecuting police that have committed crimes?
Sure. Although I think we might need to sort of clarify exactly what qualified immunity is here. So qualified immunity is a legal doctrine that was made up basically by the U.S. Supreme Court, that provides essentially a shield for the state when individuals sue the state for violating the law, for breaking their constitutional rights, or and so it actually only comes up in the context of a civil lawsuit. So it won't actually have any effect at all on criminal prosecution for future cops. But that being said, I do think it serves, it's a big piece of the puzzle here, because it's one of the things that really prevents the community as a whole and individuals who are harmed by law enforcement officers or by the government in general from holding them accountable in civil court. And essentially the way that the doctrine works, and I'm not a civil attorney, or this is a little bit away from my area of expertise, but it's not enough to show that an officer, for example, violated your rights in the course of their job. You have to sort of meet this heightened standard of showing kind of additional malice or additional intent, an awareness that they were violating the law. They weren't just making a mistake, and that they were doing it purposefully and maliciously and with sort of specific disregard for your rights. And I apologize, I may not actually have the legal doctrine perfectly on there, but that's kind of the idea. Unless you can, and basically the way that it functions is anytime someone sues the government for the actions of one of their employees, the first thing that the government does is they file a motion to dismiss that lawsuit and argue qualified immunity. And so literally the plaintiff in these civil suits has to clear that hurdle before they're even allowed to go further on into the case, and make their arguments. And so removing that barrier would make it, just simply easier for people to be compensated by the government when the government causes damage to them in violation of their rights.
All right. Yeah, thank you, Josh, for your time today. I don't have any other questions from any of the pre-recorded kind of question surveys that we had. If anyone else has any Facebook questions, they can put into the chat right now. Otherwise, really thank you everyone for joining us today. Thank you, Josh, for your time. It was really helpful, and we gained a lot of knowledge.
You're very welcome. Pleasure.